fascinating. And our first speaker is Elizabeth Root from the University of Washington, Tacoma. As I said to you before, we are a bi-campus research cluster. Elizabeth is assistant professor in the School of Interdisciplinary Arts and Sciences. She received her JD from the University of Wisconsin Law School and PhD from the University of British Columbia. Her research, education, and professional experience center on international law and policy, particularly human rights. But now, here's how she differs from the rest of us in this room. She has actually been on the ground dealing with these issues. She served for 2 years in post-conflict Bosnia as the executive officer of the Human Rights Chamber, a human rights court created by the Dayton Peace Agreement. And she has done human rights fact-finding and related work in Haiti, Namibia, Tanzania, Kosovo, Romania, China, and elsewhere. Her scholarship addresses a range of international legal issues, including humanitarian intervention, human rights, use of international standards in domestic law, gender in international law, human trafficking, and immigration reform. And she is the author of a book that is just hot off the presses, Human Rights and Humanitarian Intervention, Law and Practice in the Field. Please join me in welcoming.
Nicely reading all of that out. I was worried that I would have to explain myself as not a political philosopher or a political theorist, so I'm happy to be able to be a part of this. So thank you, Bill and Amos, for including me and for bringing us together for this discussion. In some ways, we started this conversation in Tacoma yesterday with focus on human rights and immigration and cosmopolitanism. But I actually want to start a little bit earlier than that. I teach a course on international humanitarian law, or the law of international armed conflict at UW-Tacoma. And last fall, I was teaching about humanitarian intervention and the responsibility to protect. And at the same time, a public debate was raging about whether the U.S. should accept Syrian refugees. And this was at that particular moment in time when various state governors were publicly announcing that they would not accept Syrian refugees in their states. So in that context, we were talking about humanitarian intervention in class. And I find that students are often quite enthusiastic about the idea of using force in defense of human rights. International law and international law courses can involve a lot of frustration at the limits of enforcement. So the idea of humanitarian intervention can be quite appealing. The Syrian conflict came up, of course, and the class was saying, we have to do something to help the Syrians. And that something was military force, or let's bomb Syria. And I said, is there anything else we could do to help the Syrians, something besides bombing? And there was a really long silence. Finally, one student raised her hand and said, do you mean refugees? And that moment, or what I think Bill and I were coming to call the bombing yes, refugees no response, is the origin of this paper. So I wanted to talk about sovereignty, human rights, and the responsibility to protect as a way to shift that focus, maybe more in the direction of refugees, yes, and bombing, no. Sovereignty and statehood, responsibility and non-intervention, these are fundamental principles of international law, and people have engaged with some of those ideas already this morning. Each of these concepts has shape, substance, meaning as a matter of law that's been developed over time and recognized by treaty, custom, jurisprudence, or practice. However, the contours of these fundamental concepts continue to shift, to evolve in response to other developments in international law. So new state practices, the impact of international institutions, active transnational social movements, and other changing global conditions. So my talk today will engage with the fundamental principles of international law, especially sovereignty, in their encounters with human rights, international human rights, the responsibility to protect, and the current conflict in Syria. International understandings of sovereignty have changed especially rapidly in recent decades and in the particular realm of international human rights. But sovereignty and its corollary of non-intervention remains fundamental, at least as an idea, to international law and policy. And international law, as we know, is created and limited by sovereign states, even as it shapes and constrains state action. International institutions are largely composed of sovereign states, even as they begin to exercise independent authority. Sovereign states are the primary violators of human rights, but they are also expected to be the primary guarantors of human rights. So the current conflict in Syria and the struggles of the international community to respond well illustrate a lot of the tensions around sovereignty in international law and practice. Sovereignty includes the capacity to consent to limits on that sovereignty, and the international human rights legal regime creates obligations for states regarding the treatment of their own populations. Sovereignty and territorial integrity have yielded to some extent to accommodate the rights of individuals and peoples within and outside of their states. State responsibility also exists as a legal concept, and it has expanded in this new context. State responsibility generally has arisen in relation to other states, and the conventional definition is that a state is responsible for acts that are attributable to it that are in violation of its international obligations. In the realm of human rights, states may become responsible to individuals and to groups for violations of human rights, those that it commits or those that it tolerates or otherwise allows. Most recently, the balance between sovereignty and human rights has realigned with the emerging norm of responsibility to protect, or R2P. R2P more directly reconfigures sovereignty from state prerogative to state responsibility. Here, sovereignty must exercise its capacity in accordance with international norms or risk intervention by the international community. Although R2P has mainly been invoked to respond through force to massive human rights violations, the notion of sovereignty as responsibility, both within and across state borders, has the potential to alter the relationship between sovereignty and human rights more fundamentally. So I want to begin to explore that a little bit using Syria as our illustrative case. So the current normative and institutional assemblage of human rights, R2P, and sovereignty foregrounds the use of force by some sovereign states or by the international community against other sovereign states. States that are subject to intervention essentially forfeit their sovereignty by failing to protect their populations. Now, this is a narrow and violent conjunction of ideas that itself has failed in protection, at the very least, and many would argue that it has further harmed those it intends to protect. So it's a policy that falls victim to that narrative, that false narrative of choice that's problematized by Shireen Razak and others, that we have to do something to protect human rights, so let's bomb. 5 years into the conflict and millions of refugees and IDPs later, the conflict presents as a failure of international law and of international institutions. But I think we should disrupt this trajectory and complicate the oversimplified narrative. And so I do two things in my paper, but I think I'll mostly do one thing today with the time I have. The first thing I want to do is situate human rights in a larger context of global governance, and think about the ways in which it intersects with other legal regimes. So we can think about refugee law, international law related to refugees, the law of conflict, and international criminal law as obvious other possibilities. So I'm going to just say a few brief things about that. But what I want to highlight is the way that these different frameworks create an unevenly integrated system for responding to human rights victims and violations. And I think that understanding that complexity gives us more productive ways for thinking about ways to respond to both the Syrian conflict, to the issue of refugees, and to engage with some of the questions that people have been raising here today. But I want to spend a little bit more time on the second part of my paper, which is really about whether something like the responsibility to protect doctrine and the view of sovereignty it sets forth offers the possibility to shift the existing balance away from the use of force and more towards an active protection of civilians, refugees, or IDPs. Okay, so this would be a shift to an approach that foregrounds the human versus the state, whether we think about that in terms of human rights, refugees, or IDPs. And the sovereign states that would really be the site of intervention would not be those that have forfeited their rights under the old model, but would be those in a decision-making role, where their sovereignty expands. Sovereignty becomes exercised in protection rather than forfeited in the failure to protect. So shifting the focus in that way, I think, would transform human rights protection for obviously the people that are most affected by the conflict, but might offer some ways forward and ways to respond to some of the global challenges we've talked about already. So my first point is I want to talk a little bit about the complexity of intersecting international legal frameworks. I know we'll talk about and we talked a little bit yesterday about the inadequacies of the United Nations, of international institutions, and of international law, and I think that's fair. And yesterday we talked about human rights being in crisis, which I also think is a fair point to make. Human rights is in this interesting position that it was once sort of the newcomer, and it was offered all this potential. I think the ideas capture and still capture many of us, but it's become institutionalized in the particular framework of institutions, and there's a pretty robust critique of that. The part that I think is most relevant for today is the ways in which we rely on sovereign states to put it into practice. That it's still a system that relies heavily on sovereign states, not just to kind of join into the framework, but really to be the first line of protecting human rights. And when, as a matter of practice, what happens is that states, when they do that mainly for their own citizens, right? They distinguish between the people that they are protecting. And so human rights really does not respond to particular categories of people that should be included in humans. So it struggles with migrants, it struggles with immigrants, non-citizens, refugees, and the stateless, right? These are all categories of people that we can leave out of sort of the discussion. So I think human rights continues to have a potential as an idea that has been limited by its implementation in law and practice. And I think questions of jurisdiction, a preference for national implementation, have substantially narrowed the scope of universality in ways that we need to revisit. Also, the human rights legal regime that we do have intersects with these other regimes in ways that are sometimes compatible and sometimes not. But what they do is they create a very uneven framework for responding to human rights victims and violations. So the kinds of status determinations that Andres was talking about, I would add, again, a whole bunch of categories to that. So categories matter fundamentally to law. Those of you who study law know how much law uses categories to do its work, right? So these categories matter a lot. Who you are, refugee, human rights victim, citizen, civilian, combatant, criminal, all of these categories have real consequences for the scope of your rights and the scope of your remedies. Geography also matters. Where you are can determine who you are, and that may be especially the case with the border crossers we've been talking about today. So even if we think about a brief overview of these regimes, show us that shifting categories are going to have real consequences for the people who are moving through those categories and the sets of responsibilities that are engaged in the international frameworks. Okay, so I'm not going to talk very much about those categories. We can come back to those in the questions if you want. But if we just think about in Syria, again, sort of most of the international response has focused on the use of force, and that's, again, its own sort of legal framework. But if we think about the regimes that protect civilians, the internally displaced refugees, et cetera, just in Syria, we can get a sense of the ways in which your lived experience might not change that much, but the options available to you will, depending on what category you have. So the current estimates say 11 million Syrians have fled their homes as a result of the conflict, but some have remained in Syria and some have sought refuge outside the country. If you're a Syrian citizen or resident sort of within Syria, but you've been displaced, you fit into a category, sort of a hybrid category of the internally displaced. There's not a good legal framework, although it's an expanding legal framework there, but you're essentially still dependent on Syria to protect you. If you're a civilian and you're caught in the conflict, there are other protections that may come into place that will involve not only Syria, but the countries that are involved in our conflict. So there are possibilities there too. So there are about 6.6 million Syrians internally displaced within Syria. Syrians who leave Syria cross an international border, they become migrants and refugees. As migrants, they're dependent on the immigration laws of the countries they enter. If they qualify as refugees, there are further protections in place through the refugee regime, but the durable solutions and protection, again, depend on the country that they enter, and often the process by which they journeyed, right? That can also create categories there. So at present, about 5 million Syrians have fled to Syria seeking refuge. In that way, about 1 million of those have requested asylum in Europe. Only 10%, or about 500,000, are currently living in UNHCR refugee camps. The US has accepted about 10,000. But we have taken a leading role in military. Okay, so the listing out is fairly grim, but I do it because I think it's important to keep in mind those complexities in navigating the different legal regimes. And so it unsettles that false choice of bomb or refugee, and we have to kind of think about it in a more complex way. I also think we have to think about the challenges that international institutions are facing in responding to this crisis because of their different mandates, the different possibilities that are available to them, not only that, but the question of resources and the state involvement there too. So I just want to problematize that piece of things, so we can come back to that in the questions. The second point I wanted to talk about was responsibility to protect. If you're thinking about sort of the legal frameworks and the institutions that exist, it's hard to get away from the idea of sovereign states. So I just want to say, again, I know there are a lot of cosmopolitans in the room, so it's hard to make an argument for sovereignty, but if you deal in international law, it's still such a relevant part of the vocabulary. And so it's not to say that there aren't other actors that are there. That are important. But I think this development around the responsibility to protect is very important. International human rights was successful in expanding ideas of traditional sovereignty, challenging the ideas of sort of the distinction between the domestic and the international, and what we think about in terms of state responsibility. It's hard anymore to argue that individuals don't matter in international law, and we know that how states treat their own population is a legitimate subject of international concern. So states have consented to this framework, protecting international human rights. They may have international state responsibility under kind of an international legal frame for failing in those obligations. Responsibility to protect sort of offers the next big change in how we think about sovereignty. It reconfigures sovereignty from prerogative to responsibility, and what it tries to do is, I think about the relationship between the sovereign state and the international community, however we define what that is. And it's mainly been used to respond to massive human rights violations. I think responsibility to protect offers a possibility for integrating our frameworks and foregrounding protection rather than force. And that the focus should shift to the sovereigns, not just the sovereign state that's failed to protect its population, but that next step of the process, which is what the international community is called upon to do. So where we look at those who are in a decision-making role as part of the international community. So there's a long origin story if you're not familiar with the responsibility to protect. It's not actually, it's a short origin story, but it's one of those, it has the narrative power of all good origin stories, right? It starts with Kofi Annan and these failed interventions in the 1990s, the catastrophic failure of Rwanda, the Bosnian effort, Somalia, Kosovo, and soul searching at the UN, kind of provoked in part by Kofi Annan saying, we have to do something better, we have to have some sort of criteria by which we can distinguish, we have to have a more principled approach. So it goes through sort of some iterations. There's an international commission on intervention in state sovereignty, led by the Canadians, and they do a lot of fact-finding consultations around the world, and they come up with a big document sort of laying out this idea of what it means to talk about a responsibility to protect. And they really ground it in sovereignty and thinking about sovereignty and rethinking sovereignty to include this protection towards your own population, and when there's a failure to do that, moving that responsibility into the international community. So they frame it one way. It gets endorsed at by the Secretary General at the UN. It makes it into the World Summit outcome document. It kind of goes through these high-level panels and endorsements at the UN level, and then it starts in 2006. So that's sort of 2000. By 2006, it's starting to appear in Security Council resolutions, and it's framed in language of responsibility to protect. And since then, it's increasingly appearing in Security Council resolutions, and it's framed really in terms of the state's primary responsibility to protect. But the language is there. It's laying this foundation, and it's opening the door, I think, to an international responsibility to protect. So it's gone through a couple of iterations. Where it stands now is there's kind of a three-pillar approach. And the first pillar remains focused on the state itself and the state's responsibility towards its own population. But the two remaining pillars shift the focus to the international community. So the second one is on international assistance and capacity building, and then the third pillar is timely and decisive response. So it hasn't been used in the Security Council to authorize international intervention yet. It's certainly been argued for that purpose, but it sort of hasn't made that next step, but there's a view that that has been implied. Generally, I want to talk about from a human rights perspective. Generally, in the human rights community, R2P, the responsibility to protect was welcome. State responsibility, the first pillar, is not new territory for human rights. The idea that states are responsible to protect the human rights of their populations is widely accepted pretty much since states signed on to the major international human rights treaties. But it's that international dimension that seems to hold the most appeal. But it also raises the most concern. Because of this legacy, humanitarian intervention does not have a good track record, we could say. And because of that legacy, there's concern that R2P just becomes the latest chapter in the complex and violent history of intervention by the international community for purportedly humanitarian reasons. And this gets especially, the concern becomes heightened when the responsibility to protect is operationalized as military force, and when that force is used along lines of existing power asymmetries, right? So we know that often if you put up a map of where humanitarian intervention happens, these are interventions of the global north and the global south, often along old lines of colonialism and other power asymmetries. This has not escaped attention, and there's been a growing call to kind of think about ways to reconceptualize the responsibility to protect that is sensitive to those power asymmetries and retreats from this emphasis on military force. That was definitely not the original conception. In the original conception of responsibility to protect, the idea was that military force would be the extreme option, the last resort, but as a practical matter, that's sort of where we end up. In part because it's put with the Security Council, right? So when you task the Security Council with dealing with responsibility to protect, or they task themselves, that's what we were mostly talking about. So the current configuration in three pillars leaves a lot of room for responding in other ways, other than through the use of force, through assistance, capacity building, and other responses. And there's a small chorus of voices that's starting to talk about that those responses should include more assistance to refugees, internally displaced, and more offers of asylum. So in the current framing, the first pillar is states with the states. The other two pillars focus on the international community. Now that's an imprecise term, and so there is some debate about what we mean by the international community. So for some, the logical conclusion is that international community is represented in the United Nations and other international institutions. Other bodies, because I was talking about the Security Council, that would be a place for authorization of use of force. Other bodies in the UNHCR, for example, UN human rights bodies, all could have a role as the voice of the international community in those pillars 2 and 3. But we have to remember again that these institutions remain dependent on state cooperation, on the authority that they have. And so one of the great frustrations in Syria for people who are advocating for a more forceful military response is the Security Council impasse, right? On bombing on Aleppo, just recently we cannot look to the Security Council for a solution here. But I don't think that that's all bad unless we think that the only good solution is a military solution. So another view is to think about the international community as simply being other states, acting collectively through international organizations, but also possibly acting independently as sovereigns. And so under this view, R2P could define sovereignty more broadly, not just as states' responsibility to their own populations, but a broader responsibility in their role as part of the international community. And this reconfigured sovereignty would affect decision-making in response to human rights and humanitarian crises. So Edward Luck is probably the person who's advocating this most strongly, that we have to rethink about what that means. Who are the sovereigns that we're talking about, not just the state that is failing its own population. As part of the international community, states could have a responsibility to provide assistance, not just through the use of force, but also through other means, including refugee assistance, financial support, offers of asylum, etc. So this could be a sovereignty that foregrounds protection of vulnerable populations wherever they exist, human rights victims, refugees, IDPs, rather than state sovereignty. It expands state responsibility for human rights protection, and the state would avoid some of the problems of the history of humanitarian intervention because it affects the sovereignty of the states that are the decision makers rather than the site of intervention. So sovereignty is not forfeited but exercised in extending protection, and I think that this could potentially have transformative effect. So the 6.6 million internally displaced Syrians and 13.5 million Syrians in need of humanitarian assistance would not have to look solely to the Syrian government, but would have a claim on other states. If we follow Andreas's arguments about domination, in fact, the states that are involved in the conflict most directly, we could say, in fact, would have a heightened responsibility along those lines to do more than, in many ways, to ameliorate the damage of the conflict as well. So states would also have a responsibility to protect the 5 million Syrians who fled Syria, including an expanded willingness to accept refugees and grant asylum. So far beyond really the small numbers that we have. Okay, so let me briefly conclude. I think that this is a moment of despair for a lot of us. We talked about this a little bit at lunch yesterday. It's hard not to see human rights in crisis and international institutions in crisis. But one of the things that we talk about in class, I face a lot of skeptics in the classroom about international law at Tacoma and the United Nations. But we talk about how World War II became this creative moment, for better or for worse, right? When you think about the condition of international law, international human rights before World War II, we really took the devastation of World War II and the failure of the existing frames to motivate a creative response. And I still find it incredible, with all the legitimate critiques there are for the United Nations, I find it incredible that for 70 years we've had this system of global cooperation designed to prevent war. It does a poor job in many respects, but it was unprecedented. And I'm not quite willing to throw out the 70-year history and the progress I think we've made in some ways because of the current failures. So I feel like that time was a very creative moment. It certainly set modern human rights into motion. It rejuvenated the law of international armed conflict, right? The Geneva Conventions all come right out of that same aftermath. It created or revitalized new institutions. And so it became this incredibly creative moment. And it gave us a lot of the complexities and problems we have now, but also opened up all sorts of possibilities. So the refugee crisis that's prompted now by the conflict in Syria is often compared to, cited as being the largest since World War II. And I wonder if it could offer similar opportunities to rethink the existing international legal framework. We've learned a lot in those 70 years, and things like international human rights, the refugee protection scheme, humanitarian law, the new international criminal law regime, it had profound effects in shaping contemporary sovereignty and influencing international policy. So I'm not quite ready to give up yet on R2P. I'm an R2P skeptic in terms of the use of force, but in terms of the possibilities it might offer us to reimagine sovereignty, I think we need to take a closer look at that. Okay, so thank you.
Okay, the floor is open for questions.
Yes?
Thank you, Elizabeth, for this very clear introduction for non-lawyers into especially the law on RTP and all that what is included here. And I have a lot of sympathy with your reading of finally the last concept, protection, is much more than allowing to apply military force in a given situation, since this may imply much more danger and less protection than originally thought. That is, of course, somehow and always depending on the prevailing situation. But my question I would like to pose here is what we have done as a contribution to such an important development of legal conventions in the last 10, 15 years is in a certain way referring to the given situation. It doesn't imply, and this is not your task, to think further, to think about the strategic and legal possibilities to further develop these principles. By that I mean, and this is my question, how could we overcome the unclear elements, like the open discussion, the open failing precise definition of what is international community about? If the given institution, we think first, namely the UN, is somehow not working, if a UN veto member, like in the case of Syria, is not just involved, but an active member of the conflict, how could we ever think that this institution could work in such a situation? So for that reason, I would like to ask the lawyers to give good suggestions or proposals to us for alternative procedures without putting much more danger, namely the danger of the self-determination of single nations or groups of nations. Let us, why we could think that Russia finds another conflict where in the same situation, Russia and some allies would intervene on their own right claim for this kind of responsibility to protect something. For instance, to protect the Russian population, not in the Ukraine, but in the Baltic states.
Yeah.
So this is the ambiguity we are confronted with, and we are not opposing on these ambiguities at all. But I have in mind, when you are referring to this short history, but important history of legal development, what, according to your view, are your proposals to develop this principle further in order to make this principle to a political instrument by clear and legal procedures? Otherwise, it would be just a principle without procedural elements, and this is something which undermines not only the legal state, but affects the justification, the possibility of justification of that principle in the further horizon of international politics.
Okay, so thank you. There are a lot of questions embedded in that, so let me see if I can respond and you can tell me if I get it. So I want to talk about first the part about the UN as a failure. I think that one of the things I do when I teach is show the big organizational chart of the UN, right? Because we talk about the UN, but of course it's this massive and complex bureaucracy. So if we think about only the Security Council, and we look at the Security Council in Syria, it's definitely easy to see it as a failure of the system for those of us that would like to see maybe a more robust international intervention. But I think that that's not the whole picture, and so I don't think it's not a legal system in the same way that the domestic legal system operates. I think it's a functioning legal system internationally, but it operates in very different ways at times. And so I do think that we have to think about what we mean by the UN, and so we would include UNHCR, we would include the High Commissioner for Refugee, all the special procedures that go on, and I think that there is that just like much law. It's easy to look at the big failures of law and to wonder, but we miss all the ways in which law is shaping and conforming people's behavior and working successfully because they're mostly invisible to us. And I think that's true for human rights and human rights protection. The big failures are obvious, but I think that there's a lot of small successes along the way in having people transform their own understandings what it means to talk about human rights. I think countries amazingly, in many ways, do change domestic law to fit with their international obligation. So these things do happen. So I think we just shouldn't forget that piece of things too. So I think that that's important. So it's part of that unevenness. I'm comfortable with ambiguity. People don't think that about lawyers, but in fact lawyers love ambiguity, right? So it's not as much of a problem to me. I think that there's opportunity in the ambiguity around the international community as well as limitation. And I actually think that, I'm more worried about the UN's failure around the cholera crisis in Haiti in some ways than the failures of the Security Council, which are less surprising to me So I think that there's opportunity in international community, and so what I would see as a way forward is to think about that, to say, wait a minute, what is the international community? What in fact is the UN? It has some life of its own outside its member states, obviously, it's expanded its own capacity, but let's not forget about the role of sovereign states. And here's a way where the uneven patchwork can help us. I'm sensitive to Andreas' point that we want something that works globally, not just in our own little quadrant, but it's not a bad place to hope that that begins and then spreads outward. So I continue to think that that's not all a bad model. So the UN ambiguity in terms of way forward. Was that most of what you were asking?
Procedures?
Procedures.
How could we develop further procedures?
Well, again, I think that I think responsibility to protect is interesting. And in my writing sort of on human rights and humanitarian intervention, I'm pretty skeptical. I think we don't acknowledge how much human rights is indebted to violence. So I think this was a little bit Michael's point, and that we should at least acknowledge that and problematize that more going forward. I don't like the alliance of R2P and humanitarian intervention where protection is really only about the use of force. So I think procedurally, we have an opening with responsibility to protect. It's been recognized at a very high level in the international legal system. It gives us a shared vocabulary and a lot of room in those other pillars to think about what that means. And I think it would be the greatest shame if we only proceduralized it in the context of the use of force, and we didn't kind of bring it back to these other contexts. So that would be the
I think I agree with literally everything you've said. So I don't know, but I'm still going to say things that bother me. And what bothers me is that I worry that this is a prediction and I'm not sure it's going to hold true. In part because I think this also echoes something that you said. If the difference between bombing and refugee status is that you're more likely to save more concrete humans with refugee law than bombing, then I'm on board. But if the justification is that it doesn't subject itself to the same pathologies of capture by great power politics, or even to be conceived of as violence, then I think I disagree. And I disagree because in part the declaration of someone else's polity that it's failing at the job of being a polity is going to be received as violence by those who run that polity. So there was a wonderful case where an African American walked across the bridge in Detroit to Windsor and said, I'm an asylum seeker. The US is not protecting my rights adequately. Now the Canadian said, you're probably right, eh? But on behalf of the government of Canada, we will not make the declaration that the United States has lost the right to be sovereign because we well are aware of what that entails. So my worry is this, that everything you've said, to me, is a good reason to shift R2P away from simply the use of explosives to the use of refugee law rather, but it doesn't come to grips with the fact that there's still lurking in the background here an enormous amount of possibility for the same kinds of things that made Bosnia problematic, that made the use of R2P language in Iraq so shameful. All of this is still going to have lurking within it attempts by countries to demonstrate that other countries are not doing their job and to make them less than they otherwise would be. And I think this is also the proceduralist point, that no matter how robust our procedures, we don't have any ways of preventing hegemonic superpowers from capturing institutions to do that. Syria is going to be a proxy war between the Russians and the Americans, whether there are explosives or simply refugee streams.
Right, so I agree with you. But you know, that is always the problem you're identifying of the kind of the judgment of states or the community of states in relation to a failed state or a state that's failing its population. that's always been the problem of refugee law, right? So it's not that then I can dismiss that, but it has, right? So it's not a new problem anyway. And states are very attentive to that in their policies around asylum, right? We don't have to look outside our door to see that. So I think that that's true. I don't think it solves things. I have skepticism about responsibility to protect because of the global the power asymmetries that are reflected there, and not just geopolitical. But we were talking a little bit yesterday about other kinds of interventions of the global north or in the global south or across those power asymmetries individually, like the global elite, right? The super citizens and the sub-citizens. I was using Ivan's language around that, right? So I think a lot of these international endeavors suffer from exactly that problem. So I don't have an answer for why that's not the case. I don't think it's a new problem of responsibility to protect. As someone who's interested in protecting the humans, I think if we can open up more ways to do that, I think that refugee protection or human rights protection can at least level those asymmetries a little bit if we're extending relationship and membership. It doesn't solve the brain drain problem that it sounds like you work on. So in a way, but I think it does come back to the idea of let's give an exit option for people, and that existence may shift some of the calculus that goes on, right? So, and I think that we saw that a little bit with ISIS, not to add another layer of complexity, but that the idea of people fleeing actually kind of was alarming, because if you want to try to create your own community and rule your community, then to lose people is a loss. So, yes.
I really like your argument, and I'm sympathetic to the idea of thinking about other ways in which countries can imagine the responsibility to protect vis-a-vis humanitarian crises in other countries. I just want to propose an addition, which is that responsibility to protect should also include the obligation not to assist governments that are waging atrocities against their own people, as Russia and Iran have done in Syria, sometimes even joining in the atrocities.
Yeah, it's another way that shifting, what I don't like about the responsibility to protect is it focuses on one sovereign, right? The sort of the failed state. And what you're saying is that reflecting back, right? That we think about how are other sovereigns also failing, right? By participating in atrocities, whether it's against their own populations or other populations of other states. There is a way in which it could equalize the playing field a little bit. So we think about, we're judging not just Iraq or Syria, but we're kind of thinking more about our own involvement in these conflicts. So
Can I have a follow-up question, just
sure.
briefly? I mean, and I'm just thinking about, I mean, you worry about abusive interventions, so use the concept of R2P to address that as well.
Abusive interventions?
Yes, I mean, you say
Yeah.
there's a record of disastrous interventions, so, fold that into the concept of R2P.
Well, I think the idea of R2P is that by creating criteria in advance for what would justify an intervention, that we avoid some of the past problems. But I don't think that's a hard thing to pick apart. I'm deeply skeptical about military interventions. I think that they rarely make things better. I think that they almost always demonstrably make things worse. But I also think it depends on your perspective and where you sit. So I spent time in Bosnia. Bosnia is often cited as sort of a success story, but what's been created in Bosnia does not seem like a sustain, and the international community is still there, right? Still exercising in many ways a sovereign function, completely unaccountably. So I think that, I'm not sure that R2P solves that problem. I think it tries to solve that problem. I think it gives us ways to hold the international community more accountable on the ones you've talked, but I'm not sure that we can solve that problem with a doctrine, and definitely not when the security, when we're talking about use of force and the structure that's set up in the United Nations to authorize that through the Security Council. Sorry, yes.
I just have a math question.
I'm a lawyer.
So you were were talking about the internal and external displacement of Syrians. You said 6 million internally displaced
I think that's right.
and 5 million externally displaced? So this adds up to 11 million, right?
I think that's the
So
latest.
what was it? What was
There was a
the total population of Syria prior to the civil war?
I don't know that. Someone else might know that. My numbers are from the UNHCR on the number of people affected. So I don't know what that is as a percentage of the population. Does anybody know?
It's about 22, 25 million pre-war.
So we're talking like 35, 40% of the population has been either.
Half.
Okay.
So and half of that has left, and half is internally displaced.
Thank you.
In the back, Jen.
Yeah, thanks for your presentation. I've been trying to think as we were talking, and it has been difficult for me to think along with your proposals about sovereignty as responsibility and how the responsibility to protect figures here. Because my concern is contested sovereignty and its relationship to the responsibility to protect. By contested sovereignty, I mean, let us imagine that there are two ethnic groups struggling for self-determination, and that these ethnic groups are found in 3 countries. Say, for instance, in what used to be the Upper Volta region in West Africa, in Burkina Faso, in Ghana, and in Cote d'Ivoire, you have the Chui, the Yakan people. And now, maybe they come together and say that traditionally, as ethnic groups, they have cooperated with some other ethnic group, and they are older than the nation states in which they find themselves now. And they come together and they are struggling for self-determination. Now there are 2 types of sovereignty that is being contested here. The one imposed by the unfortunate history of colonial division, and the one that is thought to be more autochthonous, more, historically embedded. Now, my concern is this. Could there be a ground to think of any responsibility here to protect? If there is, to which sovereignty does it apply? Hasn't it come to an end what the responsibility to protect can do?
Yes, I think there are limits to what the concept can do. I like it. I think sovereignty. Somebody made this point this morning. I think that sovereignty has more fluidity. It's more relational than we sometimes acknowledge, right? Sovereignty really is about recognition. That there are criteria that we look at as a matter of international law, right? That we look at population, territory, some sort of government, and capacity to have international relations, right? That's the list of 4. But there's a lot of wiggle room in those categories, right? So there has to be some population, but it doesn't have to be any particular side or particular group. There has to be some core territory, but we know there are always disputed boundaries. So there's a set of principles, and what matters really is sort of whether you're treated as a sovereign state or not. There are groups that arguably meet those criteria that don't get treated as states. There are groups that do get treated as states that arguably don't fit so well in those criteria. So I'm not as wedded to this idea. I think states exist because we decide they exist, and that's true in general and for particular states. So I remember really clearly kind of coming out of my education and really thinking of states as these stable institutions and sort of being taught about that. I think international law tries to stack the deck towards state stability. And then I graduated law school in 1989. And so immediately the world changed dramatically, and there were states breaking up and coming together, and all of it threw it into relief. And I think that when you think at all about history, right, so obviously the boundaries we have now, colonialism, had a tremendous impact on that and then decolonization. And so I don't have sort of a commitment to the particular frame that we have. I understand for reasons of stability why international law sort of favors that. But I think that I think we should open up those discussions a little bit and say that sovereignty serves a lot of purposes, that it's part of how our system functions as it does, but we know we make exceptions all the time. And so a situation like that, you know, maybe we should rethink where that sovereignty operates. I also really appreciated Amy's comments this morning about indigeneity, right? So this is another way that sovereignty is being challenged internationally that I think could be very productive in opening up new ways to think about these questions that are so important, where what it means to talk about layers of sovereignty, what the scope of that sovereignty is, how it connects to a particular territory or population. Indigenous groups' claims to sovereignty challenge a lot of that conventional thinking in ways that I think we should be open to. I'm interested in the way in which that has made it onto the international scene through human rights, interestingly, but not perfectly. It's not a perfect match there either, but it is pushing our thinking on those questions.
You kind of respond to the question I had, because it was when you said sovereignty several times, and I'll say, what kind of sovereignty? How do you define that, right? You kind of alluded to this now, because we're talking about territorial sovereignty, we're talking about self-determination, we're talking about legal jurisdiction, or all of the above. Your answer seems to be indicating that you allow for some negotiation there, which seems attractive to me. If you have some more to say about that, would be great. But another point is about R2P. It seems, I see this about human rights discourses and the appeal to R2P, you know, as a matter of mathematics as well, in the sense that, well, okay, maybe if we're talking about 4 million people, maybe it's about time to intervene, right? But kind of related to Michael's example, well, what about one person, just one person, is being subject to a terrible atrocity, terrible violation of their rights? Can we appeal to R2P in those cases? Well, if the point of this example, the exaggeration is, okay, yeah,
Right.
where are the lines? So maybe it's not 4 million, maybe it's 3,999,000. So who defines, what are the criteria, if any?
I think that's a good question. I think that our answer is not in R2P, but in human rights, right? So we think about the extreme remedy of using R2P to substitute one sovereign for another in an extreme case. But again, the framework we have established, and I think that human rights has contributed to this, is the idea for the one, or for the few, or the idea that the existing model of sovereignty is where we're going to look for that protection. So it's not a good it's not a good answer in the sense that sovereigns sometimes do a very poor job of that. So but we do look to human rights, and we have other mechanisms besides R2P. All the existing human rights machinery is really designed for those smaller cases, right? And I think we get pushed to R2P, go through your domestic proceeding, bring a human rights complaint, report to the committee, try to get international attention, invite the special rapporteur. Those are the sorts of remedies we look for on a smaller scale. But I think that the idea of, and so we rely on traditional sovereignty in those cases. And what R2B is, I think, trying to do is to get at the place where it's such a catastrophic failure of sovereignty for a particular group of its population, where the state either is perpetrating the worst violations or is unable to kind of prevent them in ways that we think states should be able to do. So that's human rights contribution, is those other cases, the smaller numbers, and it's the catastrophic failures where we maybe need to rethink about whether then sovereignty gets reconfigured in that way.
It was a quick follow-up question, because I was thinking maybe that's not the purview of states to address those issues, right? So in this case, personally, I'll be more interested in seeing subnational actors being responsible. In this case, it wouldn't be R2P, right? Churches could respond to this, charities, et cetera, et cetera, et cetera. Well, they would feel the obligation, maybe voluntarily, to address that particular violation and to respond to a particular need. And Yeah.
Yes, no, thank you, and actually you gave me an excuse to talk about Canada, which I was looking for. So I'm not just American, I'm Canadian. I sometimes feel like this, especially this militarized view of R2P or military, this use of force, connection to sovereignty is sort of an American view. But I've been really interested in watching how Canada has dealt with this too, and there are lots of ways to critique Canada and the Canadian response here too. But they have actually been much more on the side of refugees yes, bombing no, with the new Prime Minister. And what's so interesting to me about the refugees, so they're a tenth of our size, and they've taken 3 times as many refugees from Syria. And it's been really interesting to know people who are involved in that process there and the different way of discussion about it. And in Canada, it's this there's the kind of the public process, but there's all this private sponsorship too. So people are really investing in relationships and this sort of welcoming these ideas you were talking about as alternative forms of sovereignty or defining who counts as our community or our population. It's kind of an interesting experiment that's happening in Canada around that, and people are writing about it, and I think not shying away from some of the complexities of that, but you were talking about the southern border, and we've talked a lot about the US and Europe, but I think it's interesting what's happening in Canada, and it is sort of a different model of sovereignty where the sovereign is exercising that openness, that inclusion, again, not unproblematically, but in a really different way than the way the discussion is playing here. So, thank you for giving me an excuse. Yes. Yes.
Thanks. I just want to start off by telling everyone here, when you told me the story back in class, remember, you still haven't taken my advice, but I want to reiterate. I think you should give the title of your paper should be Bombing Yes, Refugees No. It would be a bestseller. But for right now, I'm wondering, I actually am sort of interested in what you think about Syria, where right now it's bombing and refugees, but there is a military response which is not bombing and it's not refugees, which is no-fly zones. Now, would you just expect that something like a no-fly zone would later devolve and we would regret it, or do you think that has a possibility of being a new kind of more creative response that might help to resolve some problems?
Wow, I feel like I'm at a presidential debate. Actually, it really depressed me in the presidential debates that Syria would come up and how we should respond, and then minutes later, if at all, refugees would come up, and there was very little kind of like connecting of the dots that I thought was too bad. I'm a skeptic on the use of force, external use of force. I am. I think that it's not that I don't see the times where it has created possibilities, but I think that human rights backed by force links human rights to force, and I think that it's hard. There are no clean hands, and I think that we can never get out of those legacies, and I think we try too hard to camouflage those legacies by calling them international. So to me, I'm deeply skeptical. So even there, it's too late in Syria because we're in and using things forcefully. I like the model. Have you seen Erica Chenoweth's work on nonviolent conflict resolution? They did a study of efforts to topple governments or do regime change over the last 100 years, and whether the use of force was better or nonviolent ways of going in. And they found that, in fact, it's generally the nonviolent movements to change regimes, even oppressive regimes, are more successful both in achieving their goals and then maintaining kind of stability after the fact. So I commend you to her work. So I think that it's that we're at that bad moment of choice with Syria, and that we had more options earlier. We could have supported nonviolent efforts towards regime change. But I do think that the better choice, I think we should open our borders to refugees for sure. I think we should financially support that. And then in the end, so that's just my opinion, but I think that those would be more productive ways of responding to Syria, because it's hard to see anything other than the intractable conflict and proxy war that people who know more than I do are identifying for us.
Yeah, thank you for the paper. I really liked the way you combined political realism in the first part with moral idealism in the second part. I mean, I wonder if the moral idealism in the second part is so ideal, and if you're not thrown back to political realism that is to sovereignty all the way down. Because you mentioned that RTP is something like a norm for responsibility, but this is also a means for advancing human rights protection. Now I wonder in what sense then this approach, responsibility, is a norm. It strikes me then that's a norm like we have industrial norms, like standardization of paper formats or screwdrivers and other tools. So if we have a certain end, that is protection of human rights, then we use certain means and we standardize our means. So we have experience which means might work and which. So this is, it looks like a moral talk because you use the expression norm, and it looks like a moral resort in the given situation. But this is just a technical norm, a standardization of, let's say, pragmatic behavior. So aren't we then stuck with the sovereign states and their decision whether they want to be a violator or guarantor of human rights? And the talk of norm in a technical sense won't help us to a kind of moral point of view.
So in a way, yes, I guess in terms of the standardization, right, that it's putting forth an argument for how sovereign, what we should mean by sovereign, and sort of raising the protect, or what it means, right, the technical aspect of it, I think I understand what you're saying. But then the question is why is that not enough, or is that a standardization that doesn't improve the situation? Are we back to the question of what should we think of something besides sovereign states? Is that what you're asking?
No, it's more just a suspicion I have that the use of norm vocabulary is in a way covering up that we are not left with moral considerations, but just political prudence. It looks like it would be a moral consideration because you use the expression norm, but all what norms refers here are technical considerations, so to speak, practical matters.
So whether I think it's more that there's a moral content to the,
right.
the responsibility to protect, I think that the argument is made that it's a normative development, that it's an expansion of our understanding of what it means to be sovereign, and the relationship of a sovereign to its population, and the way I'm arguing to other populations. In that sense, I think that that's the idea of it. I do think that as a practical matter, that we can get this sort of technical aspect of it. I think especially international work is vulnerable to that, right? To the sort of isomorphism, right? That here's what a state looks like, here's what a state does, so this is what you should do. So I think that that's a fair critique of international law. I think of human rights generally. I think that often these sorts of international initiatives do play out in that way. My empirical project on human rights and humanitarian intervention really talks about that it's this not just importing a particular set of values, but in this very technical way that it's operationalized, the kind of cut and paste model that we see in a lot of human rights work. But I also think that that can deny agency and the particularities in given context. And I think human rights also offers a lot of those examples too, where it may start out with that sort of intent that is sort of a technical set of criteria that we're looking for, but that often in practice it takes on its own form, and that there are a lot of actors in play, and so it's more of that indeterminacy that can be the negative of these international interventions and international bureaucracy and civil service, but in fact the way that they're vernacularized or the pushback that happens in a given setting has some transformative potential. And so I think that there is room for that, but it does require that there's that we allow the learning to flow both ways. That it's not just here's what it means to be responsibility to protect. I guess that maybe to go back to my Canada example, that in fact we should pay attention to the ways in which it plays out in particular settings, and it might give us more content to what we're talking about.
Yeah, thank you. What you're saying, you say bombing no, refugees yes, and so you focus on military non-intervention maybe as a wiser policy, pointing out the history of failures of those. Is there a broader argument to make about non-intervention in general, or that the focal point of international things could be to prevent countries from intervening? So I mean, Jamie Kane gave the example of Iran Russia intervening in Syria, I mean, the example Chena gave about, right, if people intervene, who do you, the intervention always favors some group over another, and there are these complex histories of sovereignty and struggles over sovereignty. So it reminds me of these debates from the 70s where people saying, what we should really do is not intervene at all, on any level. And so maybe the work of the international organization can be focused on trying to disincentivize any kind of intervention. I mean, that sounds cruel, but is that a possible
Yeah,
strategy?
yeah, maybe less cruel than we think sometimes. Yeah, I'm not a true believer. I think that sometimes no intervention would be much better. I sort of like Abdullahi Naeem's model for international intervention in terms of human rights, where I think that there's a role for our larger global community, but that a lot of the time it should involve those of us that are in dominant positions and dominant voices to take a back seat, to allow things to flourish, to create space for things to happen domestically, to enable to support and to create dialogue. But in general, I think that I'm skeptical about interventions, obviously military interventions the most. But I am skeptical of the strand in human rights that is this move towards, here are human rights and we will tell you what they are. So when I write about humanitarian intervention, the human rights kind of core that goes in after, I have this great quote from someone who says it's like how to get human rights without doing human rights, right? It's the shortcuts. Here are human rights. We will tell you what they are and how to do them, and just take our word for it. And I do think a lot of international human rights practice follows that model. So I don't think that the skepticism, I think that skepticism is good. I think we should do a lot less intervening and a lot more watching, supporting, learning from people's other experiments, and getting lessons that go in a much more reciprocal sort of way. So I do think that that's true. At the same time, I think that a lot of communities in crisis look to international support for very practical reasons that we should respect as well. And so I think you can go, in human rights, you can kind of go too far the other way and say, every place they get to decide for themselves, or people are naive to rely on human rights. But I think that after I was a lawyer, became a sociologist, so I believe kind of the empirical matters, and people use human rights in very interesting and transformative ways that they find important for advancing their causes, and I think we should pay attention to that too. So I want to walk sort of a little bit of a middle ground on that, but I would favor less intervention.
I have a follow-up question to kind of the question Thomas asked, and your response there with kind of in which sense R2P is a new norm. So I always understood it to be a new norm because traditional human rights law in a way was creating state obligations, but it was not really creating individual rights holders. And so the idea of R2P then was understood in a way of somehow saying, but if we kind of reverse the logic, it's really kind of individuals are rights holders, and then there has to be a chain of responsibility. So maybe the state is the first responsibility holder. If the state fails, then another state or another state, and so on. So it's really kind of the normative innovation, to me, always kind of was supposed to be kind of the reversal from kind of state obligations towards individual rights holders. But now this raises interesting questions, kind of what you can observe in the cases, because obviously kind of the criticism on R2P in a way would be, it's not really kind of creating a new rights logic, but it's rather creating new empowerment structures. So states who before in international law could not claim some competence to intervene in a certain situation will suddenly say, oh, given this international norm, we have kind of the competence to intervene in this situation. Right. So then one would say, okay, so it's ultimately reinforcing, right. Also making it even stronger. Before states were sovereign with respect to their own citizens, right. And now at least superpower states are also sovereign with respect to citizens right. of other states. So that's why I was wondering kind of what you would observe, for instance, in the Canadian case. I mean, do you think people and governments referring to R2P are really kind of saying, okay, so now we have to acknowledge that kind of citizens from other states are rights holders, and we have to acknowledge them as rights holders. So our sovereignty is limited. We can not decide not to react to their claims, or is it rather the competence logic?
That's a really interesting question. I don't think I don't think that R2P did that switch. I would say that that switch to what you're saying, human rights, was the sovereign obligations versus an individual rights claim. I think that human rights opened that door, and that may have been the original conception, but then in fact, as a practical matter, it did become a language of rights holders, and we saw more proceduralization where people could make claims against rights. The expectation was that not just that states had obligations, but that individuals could make claims based on those rights. And so we've seen a shift from those early days. So I think that was probably happening all along. But R2P, I would not think of as kind of enabling people to make that claim so much. I do feel like it's been very much framed in terms of sovereignty and what the additional obligations are for states. So that's sort of, I think, a lawyer's perspective on that, that it's much easier to imagine an individual asserting a human rights claim than that the state had a responsibility to protect them. So I do see it more in the other way, but it's curious to hear you kind of framing it that way. That I don't think that it's served to expand. The other thing I was going to say is sort of a legal question. I think human rights was on that path already because there have been these jurisdictional questions about what the scope of that obligation is. And that's where I think it's expanded. Originally it was sort of for your own population, and then these questions of in humanitarian intervention when you're occupying a territory or you're in charge, acting as a de facto sovereign. So these expanding jurisdiction for human rights obligations has broadened those the individual ability to bring claims in a way that I think has done more for the individual than necessarily R2P. That's my sense. That's probably more of a lawyer's answer.
Yeah.
All right, thank you very much.
Okay, thank you.